Hello from Lafayette, Louisiana. I'm Claire Edwards. I'm an attorney in Lafayette, Louisiana. I focus in family law, and I'm here today to talk about the procedure because I'm going to talk strictly about one article from Title IX, and Title IX is technically the Civil Code ancillaries. And we're talking about, in particular, the procedure of what to do when a parent either refuses to let the other parent exercise visitation, or a parent just doesn't exercise visitation and the parent who gets stuck with the child wants them to. So this is called Revised Statute 9346, action for failure to exercise or to allow visitation, custody or time rights pursuant to court-ordered schedule, judgment, and awards. I want to start off by identifying that in this code article, attorney fees and court costs are allowed. That's not for every single family law issue, certainly not for plain Jane divorces. You have to pay your own attorney fees. In this case, if we have a parent who violates their custody order and the other parent brings this against them, yeah, they're going to owe some attorney fees and court costs if the court finds that they did it intentionally. So let's dig into these exact words. And they're pretty parallel between failure to exercise child visitation and failure to allow child custody. So I want to stress that one of those is the parent is choosing not to see their children or child, and the other parent is saying, whoa, 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 I need some me time. Come see your kid. And then in the other case, there's a failure to allow child custody, meaning one parent saying, oh my God, it was my weekend. You didn't answer the calls. You didn't meet at the meetup spot. It was my weekend. I want to see my kid. Let me see my kid. And the other parent just continues to ignore. That parent who wants to see their kid is the one who is bringing this suit. So in all of these cases, an action for the failure to exercise or to allow child visitation, custody, or time rights pursuant to the terms of a court-ordered schedule may be instituted against a parent. The action shall be in the form of a rule to show cause why such parent should not be held in contempt for the failure and why the court should not further render judgment as provided in this section. So there's two procedural things that immediately pop up to me in just reading 9346A. The first procedural thing is you're filing a rule to show cause. This means you already have your open custody case. You're not filing a new case. You're not filing a petition. You're filing a rule to show cause. What is this? I'm going to see if I can add some graphics later, but where's my hand? A rule to show cause. Anyway, why such parent should not be held in contempt for the failure, and why the court should not further render judgment as provided in this section. So the second procedural thing is when we get to court on that rule day, our attorney, if we're a parent, or us, if we're the attorney, better have prepared a judgment. What can that judgment say? And now let's go over what that judgment can say. The judgment can say if the action is for failure to exercise child visitation and the petitioner is the prevailing party, the defendant shall be held in contempt of court. So number one, we're looking at contempt of court. And again, it's reciprocal for section C. If the action is for failure to allow child custody visitation or time rights, the petitioner is prevailing, the defendant shall be held in court, contempt of court. Cool. So one, we're looking for contempt of court. Two, this statute gives all costs for counseling for the child, which may be necessitated by the defendant's failure to exercise visitation. All costs for counseling for the child, which may be necessitated by the defendant's failure to allow visitation. A reasonable sum for any actual expenses incurred by the petitioner by reason of the failure of the defendant to exercise rights pursuant to a court order visitation. A reasonable sum for any actual expenses incurred by the petitioner by loss of his visitation, custody, or time rights. So when we're looking for that parent who the other parent is failing to take the child, we're talking babysitter costs, we're talking any kind of childcare issues that they've run into that during the parent's custodial time who chose not to take the child. When we're looking at the failure to allow child custody, those costs aren't that significant. The problem's going to be, say, one parent has planned a vacation, and that vacation is in fact in compliance with their custody schedule and has formally been agreed to by the parent who suddenly says, no, you can't have the child, and has no good reason to say that. That's something they're now going to have to pay for, is the cost of that child attending that vacation. Obviously not the cost of the whole vacation, but of that child not being able to attend. Whatever plane ticket or individual like Disney World ticket would have been attributable to that particular child. Again, they have to be actually incurred. So if the parent who originally planned the trip canceled the trip, they didn't incur anything. That's what we're looking at. A reasonable sum for a caretaker of the child based upon the hourly rate at the time. And then, so that's the one for failure to exercise, when, again, you need your personal time. Now, for the failure to allow child custody, now we have, and this is the only distinction between the two, additional visitation, custody, or time rights with the child equal to the time lost. The judge is allowed to order a judgment giving that parent more time. The judge is allowed to say, I know you're about to have next weekend, but I also want you to have the entire week in addition to next weekend. So parents who fail to allow child custody are at a risk for a judge to not give them their child when they otherwise think they should have their child. Now, in practice, do judges actually do that? I haven't seen it much, but the whole point of this discussion is, what does the statute allow? The statute allows for the judge to give extra time. And then finally, like I said in the beginning, all attorney fees and cost of the proceeding is something that can be awarded in each of these cases. So the court may award a reasonable penalty to the petitioner against the defendant upon finding that the failure to allow or exercise visitation, time, or custody rights pursuant to the terms of court order visitation schedule was intended to harass the petitioner. So we're talking procedure. The procedural issues I see here is the petitioner must show harassment, whether it is the parent chose not to pick up the kid, or whether it is the parent chose to keep the kid from the other parent. There must be proof of harassment. How do you prove harassment? Generally, text messages are great. Facebook is great. Any kind of written word in exchange between the parents that shows an intention to cause irritation to the other parent, that's beyond what a reasonable way of looking at things is. So yeah, there can be a penalty there. The court may award attorney fees and costs to the defendant if he is the prevailing party based on actual expenses incurred. So again, the court shall award the petitioner all attorney fees and costs of the proceeding. That's court costs and attorney fees. The court may award attorney fees upon the actual expenses incurred. Let's get real for a second. When I get attorney fees awarded to me, I can submit my affidavit to my court, and the affidavit will say, Claire worked 2,500 hours to get this petition into the court, to get this motion, this rule to show cause into the court. And then she's been in court for another day. So let's add to that 2,500, $800 of 4 hours of sitting and staring at the walls. That full $2,500, $3,300 is rarely awarded when people win. This statute opens up that door. This statute gives the judge that option. And that's in addition to just this regular attorney fees that's listed above. Again, regular attorney fees being the judge saying, oh, good job, you hired an attorney, take $750, take $1,500. We all know attorneys are not that cheap. So this again says based on actual expenses incurred. The court may require the prevailing party to submit proof showing the amounts to be awarded pursuant to this section. That's a may clause. That's really interesting. It should be a shall clause, but hey, whatever. Anyway, the actual expenses is to say, if you hired that babysitter, you damn well better print out the Venmo from hiring that babysitter. And I mean, my babysitters are paid for not necessarily babysitting. So if you're hiring a babysitter while your other parent is not taking the child, please write babysitter and the date and the time at which time that babysitter is working for your kids. You have to be very aware of your cost to be able to pursue a procedure like this. There's that word again, a procedure. It shall be a defense that the failure to allow or exercise child visitation rights pursuant to a court-ordered schedule was made by mutual consent beyond the control of defendant or for other good cause shown. I have had often instances where I want to bring this statute, but I can't. My clients will do things like say, okay, you have the opposite weekend. And then, oops, I forgot I had to do something that weekend. And at that point, it's mutual consent that you're not with your kids. So that's not the kind of case that this is contemplating. Beyond the control of defendant. Hey, we all lived through 2020. So if we have a parent who's living in California and another one who's living in Louisiana, we can't get on a plane and send that kid during COVID. So there's no room for this statute because it's beyond the control of the defendant. Now, could that particular couple use a vehicle if they had traditionally used a vehicle rather than traditionally using a plane? Yes, and that would be within the control of the defendant, barring work schedules. I mean, if both of them were supposed to be behind a desk, those are the kind of considerations the court has to make. Or for other good cause shown. And then this is just what gives the judge all the authority. This is one of those you really have to know your judges. For other good cause shown means whatever the judge thinks is best. A pattern of willful and intentional violation of this section without good cause may be grounds for a modification of a custody or visitation decree. This is one of my favorite lawyer hacks, actually. I like to stress to my clients, wait until you find that your ex is failing to exercise their visitation, or wait until they're keeping that kid from you. Don't give them any room. Don't give them the opportunity to have mutual consent. No, you hold tight on what that court ordered you. Don't give any beyond the control of the defendant business. No, make sure that they are accountable for themselves. You be accountable for yourself. That way, after a pattern of willful and intentional violation of this section, without good cause, the grounds for a modification of a custody or visitation decree are there. So now I can file this 9-346 and also tack on a request to modify the custody or visitation decree. And guess what that helps with? That helps with this, where it says the judge is allowing additional visitation, custody, or time rights with the child equal to the time lost. That's that failure to allow child custody part. That's when I can go in and say, you got to modify it and give this parent additional time. And that makes a lot of sense because now we're not working off an old judgment. We're working on the new judgment that has come about from this 9-346 plus a modification. And now we're modifying custody too. This section applies to judicial orders involving sole or joint custody. This action is authorized and shall be in addition to any other action authorized in this section. Most recent edits were in 2010. June 17th of 2010 is the most recent time this took effect. So thank you for bearing with me. We read a whole statute together, and I hope I can break it down through graphics and comments, and ideally I'll have little things of interest. Graphics in my videos. Fingers crossed that I will have that soon. And I'm Claire Edwards. I practice family law in Lafayette, Louisiana. And today we talked about what happens if there is a failure to exercise visitation or a failure to provide visitation. We talked about it from a procedural standpoint because that statute is found in Title IX. Have a great day and enjoy your family law procedure.